We're back. I'm Howard Stevenson with Connor Boyack.
So we are now going to bring on Marina Lowe. Marina is the deputy. Oh, am I going to get your title right, Marina? You tell me so many times. Legislative and Policy Counsel of the ACLU of Utah. And so we want to talk, Marina, with you about this Supreme Court case. So first, let's maybe talk about the case itself. And then I know you have kind of this very compelling argument of a tie-in to the prescription drug case. So first, bring us up to speed. The Supreme Court heard Carpenter versus United States. Maybe what happened that triggered this prosecution, and what's at stake in the court case?
Yeah, it's a really exciting case, so I'm really happy to be on the air today to talk a little bit about it. So Mr. Carpenter was charged in a robbery situation, and the way that the FBI agents were able to establish that he was the individual who had committed various robberies at a number of different store locations was that they actually were able to get records from his cell phone company that placed him and his cell phone near a couple of the locations where these robberies had taken place. Now, these records, these cell phone records, were obtained without a judicially approved warrant, and so the ACLU, as his attorneys, objected and said that these were taken in violation of the Fourth Amendment, and so there was litigation that sort of went forward from that perspective all the way up to the Supreme Court, who just heard arguments a couple of days ago on this question of whether the information that is contained in your phone, and really this idea that your phone is constantly pinging cell towers and therefore giving really revealing information about where you go. I mean, we live in an age now where most people have their phone on them at all hours of the day and perhaps the night as well. And, you know, that can reveal all sorts of information about, you know, the places that you go during the day, the churches that you visit, the places where you might, you know, spend your time if you go to a shooting range, all sorts of different activities that you might not necessarily want the government to be able to have that sort of round-the-clock surveillance capabilities.
Now, part of their argument, if I'm not mistaken, was on the FBI, I should say, is that, well, we're not actually getting the contents of the calls, right? So the expectation of privacy is lower. Am I correctly characterizing that argument? And if so, what's your response?
Yeah, so what the government relied on this very sort of antiquated at this point doctrine from the 1970s called the third-party doctrine. And the idea is that, you know, if you willingly share your information with a third party, then you lose any expectation of privacy in that information. And so the idea goes that when people sign up for a cell phone service, they understand that the cell phone company is constantly pinging their phone and basically establishing their whereabouts at all different times, and that information is given voluntarily to the cell phone provider, and therefore you have zero expectation of privacy in that information. And I just think that there's no way that that can possibly be true, right? That we, by virtue of the fact that we now have this amazing technology that we all carry in our pockets at all times of the day, that we no longer have any privacy about the locations that we travel throughout the day and the places that we go. That just doesn't logically make any sense. So the court was really being asked to reconsider this third-party doctrine notion. It's previously been upheld by the Supreme Court in a couple of cases that are quite old at this point, dealing with bank records and then dealing with traditional phone numbers and the ability of a telephone company to keep phone numbers. But this is the first time that the Supreme Court, at least, is being asked to reconsider the third-party doctrine. Now, I should just state also, just because I'm so proud of Utah in this regard, that our own Supreme Court has taken an entirely different position on the third-party doctrine. There's a case called, I think it's State versus Thompson, dealing with bank records also, a case from the early 90s here in Utah, where the Utah Supreme Court said, nope, we feel that our equivalent of the Fourth Amendment, because of our history here in the state of Utah, should afford greater protection, and we don't believe that just because you pass this information on to a third party that you're necessarily losing all privacy protection.
So, Marina, this is Howard Stevenson. I think some of our listeners are thinking, well, but if somebody has done bad things, if somebody's a criminal, if somebody's a terrorist, isn't it okay, whether through a third-party loophole or direct surveillance, isn't it okay for government that's trying to protect us to violate the Fourth Amendment protection against unreasonable searches and seizures and to do it in our best good? Why?
Well, Yeah, I understand that argument, and there are always, of course, people for whom we could think that an exception might be okay. There are the really bad characters out there for whom we might decide it's all right if the government breaks the rules in this instance. But the problem is that our laws have to govern all of us. So if we make an exception for the bad guy, that means that the government also has the discretion to perhaps compromise the rights of somebody who's doing nothing wrong at all. So I think that's a really dangerous path to go down, to decide that just in the name of the really egregious cases, we'd be willing to compromise people's rights, because then we've really opened the door to compromising all of our rights.
As you know, following 9/11, we had the Olympics just a few months later, the Winter Olympics right here in Salt Lake City. And the Bush administration, the FBI, and the NSA, all of those folks decided they were going to violate the surveillance prohibitions, the unreasonable search and seizure, and they were tapping our phone calls, they were tapping our text messages, all in the interest of security. But Rocky Anderson is heading a lawsuit, and I'm a plaintiff in that lawsuit against the Bush administration for illegally surveilling our phone conversations and texts without a court order. You know, talk about court orders in this case. What are the conditions under which they can surveil them with a court order?
Yeah, so what this case is really asking, the Carpenter case, and I'm so grateful to hear about your involvement in Rocky's case too, Howard. That's incredible. But what the court order is really asking for, and what the ACLU is seeking that the government must comply with, is a probable cause warrant. You know, the government needs to establish that it's not just going on a fishing expedition looking for anything and everything. They need to have reasonable suspicion. They need to have, clear facts, or at least something that would identify that they believe you as an individual did something related to a particular criminal activity. So it's got to be more than a hunch. It's not an unreasonable standard. You know, we see law enforcement obtain warrants all the time based on this standard. But, it's more than just being able to look up anybody's name on the hunch that you think maybe something happened. Or perhaps, in the case of somebody who, wants to go after somebody they don't like, you have to really establish to a court that you think that wrongdoing happened. And by way of just sort of connecting the Carpenter case with the case that Connor mentioned at the outset, related to a case the ACLU has brought, related to prescription drug records, I think that's really an interesting connection. There was a case a number of years ago where there was a belief that certain medications were stolen from an ambulance down in Cottonwood Heights. You probably are familiar with the scenario. And instead of, doing a thorough investigation and narrowing in on just the individuals who might have had access to that medication, the investigator in the case went ahead and searched all, almost 500 employees of the Unified Fire Authority in the prescription drug database. Didn't get a warrant, didn't sort of narrow it down to the particular individuals who might have had access and might have been capable of committing the crime. And so, violated their privacy rights, in essence, by looking through their medical documents and finding, perhaps all sorts of sensitive information about conditions they may be suffering from, prescriptions that were prescribed by doctors to treat, medical conditions that they might not necessarily want to have made public.
Right.
So that's the sort of information that we're talking about that is at stake in both the Carpenter case and the related litigation that took place here in Utah.
So, Marina, help our listeners understand from your legal perspective the implications of this case. And let me set up the question this way. The Utah legislature, with your guys' work especially, and Senator Todd Weiler sponsoring the legislation, required a warrant to access the prescription drug database. And now the feds come in and sue and win. And so now that has ramifications for the efficacy of that law. Similarly, former Representative Ryan Wilcox with ACLU and Libertas promoting this legislation required a warrant to access, among other things, the location information of a cell phone, which is what we're talking about in this most recent Supreme Court case. Where do those laws stand if the courts are willing to allow at least the federal government to circumvent them? And even if the courts say that they don't need a warrant, What does that do to state and local law enforcement? From your perspective, can the legislature still require that higher standard of officers that are, authorized and deputized by the state, and the feds just have a looser standard, or would this trickle all the way down?
Yeah, that's a really good question. So I think it is important to note that although the DEA, the federal government, came in and said, we're not going to comply with the warrant requirement to have access to the prescription drug database, and they won, and unfortunately the state of Utah decided not to appeal that decision, which, in light of the Carpenter case, I think might have yielded a really good result if they had chosen to go down that route. Nevertheless, state officers are still bound by the requirement. So the only thing that was challenged in that lawsuit was whether the federal government needed to comply with the warrant requirement. So state officers still do need to get a warrant before they access the prescription drug database. The same is true with the legislation that you mentioned that was passed a couple of years ago, I believe in 2014, regarding cell phone location and the need to get a warrant. That legislation is specifically directed at state and local law enforcement, so does not include federal officers as well. I think the real import of the Carpenter case is the fact that, Utah was one of the very first states to require a warrant for cell phone location tracking, but many other states have not yet gotten there, have not yet realized the real privacy implications at play. And so it's really a patchwork across the nation. So the importance of this case is that it would establish sort of once and for all that cell phone location information is incredibly sensitive and just as deserving of Fourth Amendment protections as our founders would have considered, opening somebody's door and, following them in a more traditional sense.
Let's talk about the history of Utah's prescription database. It was created to help control or monitor so that doctors would know when somebody was trying to get too many opioid prescriptions because they were addicted, and they would have to connect that kind of information. It was so loose that any law enforcement officer could go onto the database and graze to see who was getting opioids. And there was a case in Uinta Basin where a police officer who himself was addicted would see when a couple got a prescription refilled, and they would go in and say, he would go into their home and say, I need to look at your prescription and count how many you have. And in counting, he would take a few himself. And I mean, it was that loose. This private information that's protected under HIPAA was that loose that our police officers were actually just able to go on at will.
Yeah, in fact, the statute is pretty incredible. If you take a look at our statute, it says this information is private, and then it lists in subsections who has access, and it's like A through N or A through Q. There are all these different subsections of people who actually do have access. And one of those subsections, of course, was law enforcement, and the legislation that was passed in, I think it was 2016, of course, sort of narrowed that down and said, no, you can have access, but you need to get a warrant first.
Marina, thank you for joining us today. We'll be watching this court case closely. We appreciate the ACLU's good work on this. We're going to hit a break here really quick and come back for our Talking About Bitcoin on Red Meat Radio.